On October 16, 1975, the International Court of Justice ruled that Morocco had historical ties of allegiance to some Sahrawi tribes, but no ties of territorial sovereignty over Western Sahara at all, and that the territory's people were entitled to self-determination. That same day, Morocco's king announced a march of 350,000 civilians into the territory the court had just ruled didn't belong to him. 50 years later, both the march and the ruling are still being argued over, often by people quoting the exact same paragraph. Western Sahara is the last territory in Africa still listed by the United Nations as a non-self-governing territory, a place decolonization was supposed to reach, and never fully did. Spain colonized it in 1884 and withdrew in 1975 without holding the referendum it had promised, transferring administration to Morocco and Mauritania instead. Morocco now controls roughly 80% of the territory, behind a 1,900-mile sand berm it built and fortified. The Polisario Front, the Sahrawi independence movement, controls the rest and has governed a population of Sahrawi refugees, over 170,000 of them by UN Refugee Agency estimates, in camps across the border in Tindouf, Algeria since 1975. A UN mission created in 1991 to organize a self-determination referendum has never actually held one. 1884, Spain colonizes the territory as Spanish Sahara. 1963, the UN adds it to its list of territories still owed decolonization. October 16, 1975, the ICJ issues its advisory opinion. Morocco announces the Green March the same day. November 1975, the Madrid Accords transfer administration to Morocco and Mauritania as Spain withdraws, without UN approval and without the promised vote. 1976, the Polisario Front declares the Sahrawi Arab Democratic Republic and war begins with Morocco and Mauritania. 1979, Mauritania withdraws and renounces its claim. Morocco moves into the territory it vacated. 1991, a UN-brokered ceasefire takes hold, with a referendum mission, MINURSO, sent in to organize a vote that still hasn't happened, stalled for decades over who counts as an eligible voter. 2007, Morocco proposes autonomy under its sovereignty as an alternative to a referendum. November 2020, the ceasefire collapses after Moroccan forces move on Sahrawi protesters blocking a road at Guerguerat. Fighting resumes for the first time in 30 years. December 2020, the United States recognizes Moroccan sovereignty over the territory, tied to Morocco's normalization of relations with Israel. October 2025, the UN Security Council renews its mission, but for the first time names Morocco's autonomy plan as the actual basis for future talks. Morocco's own position, published through its official Sahara portal, doesn't describe this as a colonial dispute at all. It describes the Sahara as historically and legally Moroccan, restored rather than acquired, on the strength of the same pre-colonial ties of allegiance the ICJ itself confirmed existed. In this frame, 1975 wasn't a land grab. It was decolonization completing itself in the only realistic direction available, given that Spain was leaving regardless, and no other state had ever exercised sovereignty there. Morocco's 2007 autonomy initiative, in its own account, is the serious compromise: real self-governance, a regional parliament, local budget, local police, under Moroccan sovereignty, not full independence, but not the status quo either. Rabat points to a widening circle of countries, opening consulates in Laayoune and Dakhla, and to October 2025's UN resolution naming its plan the basis for talks. As evidence, the world is increasingly agreeing this is the realistic path, not just Morocco's preferred one. The Polisario Front's own statements, issued through the Sahrawi press agency, start from a different piece of the same 1975 ruling. The ICJ explicitly found no tie of territorial sovereignty between Western Sahara and Morocco, and explicitly said the principle of self-determination applied. In this frame, everything since the Green March, the Madrid Accords, 50 years of administration, sits on top of a legal foundation the world's own court said didn't exist. The Sahrawi Arab Democratic Republic, proclaimed in 1976, presents itself as a government in exile still waiting for a vote it was promised by the UN itself in 1991. Polisario's position is that it will not be a party to any process designed to legitimize what it calls Morocco's occupation, and that a just solution has to guarantee the Sahrawi people's non-negotiable right to a free, transparent referendum on self-determination, not an autonomy plan designed and offered by only one side of the dispute. Here's what 50 years of this dispute keeps circling back to. Both sides are still citing the same three sentences from the same 1975 document. Morocco cites the part confirming historical ties of allegiance. Polisario cites the part denying territorial sovereignty and affirming self-determination. The International Court of Justice never resolved which of those two findings should govern what happens to the territory. It simply stated both, in the same ruling, on the same day. And Spain, the one government the UN still formally lists as the territory's administering power, the only one with a recognized legal duty to see decolonization through, has had no practical presence there for 50 years. The party the UN says is actually responsible left the room in 1975 and never came back, while everyone else fought over the seat. Every dispute in this series eventually runs into a version of the same discovery. The document everyone assumed would settle things sometimes had two different answers folded into it from the start. Sèvres and Lausanne set two different maps of the Kurdish region 3 years apart. The Boxer Protocol wrote a security clause in 1901 that, seemingly by no one's specific intention, remained available for someone to use in 1937. Here, one ruling, issued in a single afternoon, contained both a yes and a no, and let 50 years of argument choose which one to hear. Maybe that's the addition this episode makes. An authoritative ruling doesn't stop being ambiguous just because a court signed it. Sometimes the most contested sentence isn't the one nobody wrote down. It's the one two different sides both wrote down accurately from the same paragraph and still can't agree on. A court that said both yes and no on the same day, a berm 1,900 miles long, and a referendum that's been 3 decades in the making without a single vote cast. Next time, we cross to a 3.5 square mile peninsula on Europe's southern edge, where a nearly identical argument about a 1713 treaty has been running for over 300 years. This time between two countries that call themselves close allies everywhere else in the world.